From a legal perspective, special needs trusts are at the core of special needs planning. Before digging into various aspects of creating and administering a special needs trust, let's first understand what it is. In brief, a special needs trust is a legal arrangement that allows individuals with disabilities to have funds set aside for their care and needs without jeopardizing their eligibility for government benefits like Medicaid and SSI. Selecting an attorney is a pivotal initial step in this process. Establishing a special needs trust requires legal expertise to ensure compliance with relevant laws and regulations. A knowledgeable attorney ensures proper trust creation, safeguarding the interest of the individual. Two membership organizations to look for include the Special Needs Alliance and the Academy of Special Needs Planners. Both organizations have online directories based on the location. To reiterate, assets held within a special needs trust do not count towards asset limits for means-tested government benefits. This protection adds a layer of security for continued access to vital programs, even with potentially substantial assets owned by the trust. Special needs trusts come with administrative responsibilities, including managing the assets and distributions, and compliance with state law and record-keeping requirements. Efficient and legal operation is essential. These trusts are designed to supplement government benefits an individual receives. Without jeopardizing these benefits, the trust bridges the gap between the needs and program coverage. Now let's explain the two different types of special needs trust. We'll begin with the self-settled or first-party special needs trust. These trusts are irrevocable, meaning they cannot be easily altered or revoked once established. The first-party aspect refers to how the trust is funded. In this case, the funds come directly from the individual with disabilities, referred to in trust lingo as the beneficiary. A self-settled trust can become necessary if an individual receives a personal injury settlement or inherits assets directly to their name while needing to preserve their means-tested benefits. In this case, the individual places their assets into the trust. The trustee and administrator manage the trust assets and handle the distribution requests, which are allowed only for the sole benefit of the individual who created the trust. A pooled trust option is available, which combines assets from multiple individuals but maintains subaccounts for each beneficiary. In Wisconsin, we're fortunate to have WISPAC, which is a national leader in pooled trust services. First-party special needs trusts can expedite Medicaid qualification. It's very important to note that Medicaid state recovery applies to a first-party special needs trust. This means that upon the individual beneficiary's death, the state of Wisconsin can recover the cost of Medicaid benefits paid throughout the individual's life from the remaining trust assets. After the state receives their IOU, the remainder assets can be distributed to other beneficiaries as listed in the trust. The other type of special needs trust is a third-party trust, meaning that it is funded by someone other than the beneficiary, oftentimes family or friends. We recommend establishing these as standalone living trusts during the donor's lifetime. They also can be executed as testamentary trusts, which are validated under the donor's passing through their will. Unlike first-party special needs trusts, third-party special needs trusts are not subject to Medicaid estate recovery. So, upon the beneficiary's passing, the remaining funds can be directed as desired by the creator of the trust. It's proper planning for the third-party special needs trust to receive inheritances on behalf of the individual with a disability. Retirement accounts, life insurance, investments, and personal residences are all commonly owned by third-party special needs trusts. A third-party trust can also elect to stretch inherited IRA distributions over the beneficiary's lifetime, making it quite tax effective. Third-party special needs trusts often serve as the cornerstone of estate planning for families with a member with special needs. They ensure benefits remain accessible to the individual and provide additional financial support where needed. While family members play a critical role in establishing these trusts and funding them, we do recommend considering hiring professional trustees, especially as parents age and pass away. This will allow siblings and other supporters to focus on their relationships and the care of the individual versus being concerned with the financial and administrative requirements of being the trustee. Siblings, supporters, and caregivers can all be named as trust protectors for the special needs trust, allowing them to provide oversight to the overall functioning of the trust and ensuring the trustee is accountable to the needs of the individual. In summary, special needs trusts are essential legal and financial tools that protect the assets of individuals with disabilities, ensuring access to necessary resources without jeopardizing eligibility for these crucial benefits. When properly established and managed, these trusts significantly enhance the quality of life for individuals with disabilities and provide peace of mind for their families. Thank you.